Good afternoon and welcome to today's live stream webinar. Great to have you all online. So if you're joining us for the first time today, my name is Brad McDonald and I'm the host for today's panel discussion. I'm one of the business owners at Godfreys Law and I have 20 years experience specialising in employment law, and I also advise clients in the field of business law. Regardless of what level we're at, there's a lot of uncertainty still for businesses and business owners. There's still a hell of a lot of things to consider, especially with the announcement that's due this coming Monday, the 11th of May, about when the country will move to level 2. And obviously we've heard some information today, if you've managed to catch it, on what level 2 will look like, and it's great to get some clarity around that, and hopefully that's going to be further help for you and your business. So in order to discuss the ever-changing situation, I'm joined today by some familiar faces, for those of you that have been following our live stream webinar series, as well as one new face. Today we're going to be looking at ways business owners might protect their assets against business risk. We're also going to have some discussion around director and shareholder responsibilities through this evolving situation and some steps that companies can take to weather the storm, and then we're going to get some practical accounting advice and insight from Joe Dunn. So I hope that each of you will find something here of value today, and keep a lookout at the end of today's webinar for how to get in contact with any one of the panellists that are here today. So today, turning to the panellists, I'm joined by three highly qualified and experienced panellists. And I'm going to ask each of those panellists to briefly introduce themselves. So first, I'll hand over to you, Joe, who's from PKF Goldsmith Fox Accountants. Thank you.
Brilliant. Thank you, Brad. So welcome again to everyone that was here last week. It was really good to be able to join Godfreys to run these webinars. I think it's really good getting that mix of sort of legal and accounting advice, because I mean they do interlink. But yeah, so thank you everyone who's come along. So yeah, I'm accountant at PKF Goldsmith Fox. I've been with them for 2.5 years, but I've actually been accountant for 25 years now, which is quite scary. And what we do that's, I guess, probably sort of different from a lot of other accounting firms is we're really good on the compliance side, but we also love being able to help support and grow our businesses. So we do run a lot of education and webinars and just that sort of support for clients, which I think is really, really important at the moment with what everyone's going through, and you know, everyone's at such different stages. So thank you, Brad.
Awesome. Thank you, Joe, and great to have you on the team again today. Rightio, Charles, our new face, I'll hand over to you to introduce yourself, please.
Hello. So my name's Charles Mullins and I'm one of the lawyers here at Godfreys Law, associate. My areas of particular specialism is relationship property and trusts and asset protection. So I'm going to talk a little bit about trusts today for those of you who may have them, and also it may be of interest for those of you who don't have them but perhaps are thinking about getting one at some point in the future. Yeah, so I'm looking forward to sharing some of those thoughts with you. Over to you, James.
Great. Thank you, Charles. James.
Hello, everybody. Welcome back if you've been tuning in before, and to those new faces, I'll briefly introduce myself. I've recently joined the team at Godfreys as a solicitor. I've come to the law late in my career, I suppose, so far. The last 20 years I've spent in business. So my particular interests are in employment law and commercial and company law matters. So I have been looking at the new bill moving through Parliament at the moment in relation to some of these anticipated changes to the Companies Act, and I'm looking forward to talking to you all about those today. And I'll pass back to Brad.
Awesome. Thank you, James. Great. So they are today's panellists. So today we're going to start off with you, Joe, and hear a little bit about what you've been doing and some of the insights that you'd like to share with today's attendees. Thank you.
Brilliant. Thank you, Brad. So probably in the last week for us, or week or two, we've been doing a lot of work with clients through through funding that clients have received through the Regional Business Partners Network, and I may have mentioned it last week, but we are running cash flows, doing a lot of cash flows for clients and business continuity plans. So Regional Business Partners sort of works in through New Zealand Trade and Enterprise, and these, clients are getting 100% funded for, for any sort of work that we can do to help support them. And I believe, we've probably had quite a few sort of signed up for it already. So that's been fantastic because, for us clients, they need this help, but, the cash flow is not necessarily there to be able to afford that kind of advice. So yeah, it's fantastic that we've been doing that, and it's really good sort of quality work for us. So that's what we've been doing. And I suppose the other bit that keeps us really busy is keeping up to date with everything that has been happening, IRD updates. So I suppose first of all, obviously, I guess people would have seen the 1 p.m. announcement today about what level 2 means, and we're working through that as a team. What does it mean for us, heading back into town or whatever. And then also for me, it's really sort of thinking about clients and businesses, especially the ones that haven't been able to open at level 3. So yeah, I'm feeling sort of quietly positive that a huge chunk of the economy will sort of be back up and running at that level 2 stage. But we're aware that clients still need help. Cash flow, like we talked about last week, is absolutely crucial. So since we ran last week's webinar and talked a lot about cash flow, there's been an announcement about a small business cash flow scheme. So I think this has sort of come about as a result of the government-backed sort of scheme with the banks hasn't been as easy to obtain the funds, I guess, for a lot of clients. So this small business cash flow scheme is really aimed at these small and medium-sized businesses. So what's happening there is the loans are available. It's a base of $10,000 for a business, and you can apply for an additional $1,800 per full-time employee, and that includes yourselves as well. So if you're a sole trader, you could get $11,800, and you can go up to 50 employees and you could actually get a loan for as much as $100,000. So this scheme is actually going to be sort of run through inland revenue, which is probably a little bit different to other schemes, and it is anticipated to be available from Tuesday 12th of May. So we don't have the detail at the moment about how to apply, but we're guessing it'll be probably through the usual inland revenue website, which is the MyIR. So the eligibility criteria is basically the same as that wage subsidy scheme. So the loans are available to self-employed, including sole traders, and like these sort of small to medium-sized businesses. The money can be used basically for your core business operating costs. So that's your rent and your insurance, your rates, utilities, etc., etc. And it's available to any business who intends to remain open during the COVID crisis. So what's looking to be a really good advantage about this loan is that they're interest-free if the loan is paid back within a year. So inland revenue, they administer the payments of the scheme, and so that sort of takes care of it there. I think you can have the loan for as much as a 5-year period, and the interest rate will be 3%. So it is looking quite positive. It's just a temporary measure for a lot of these businesses that can just help to get that cash flow on board, basically. So we're really looking forward to that coming on board next week, and clients hopefully applying for that. And the other thing I was going to sort of spend a bit of time talking about, but I do understand from Brad that we're going to actually have a bit of a specialist panel next week, is just talking, I guess, when you look at our tagline for today's webinar, it's keeping your business running or not. So I was going to spend a bit of time talking about the or not, but like I said, I think we'll go into more detail next week. But I guess it's just, from what we do at PKF is we do help businesses when they want to close. We don't do any sort of insolvent liquidations or anything like that, but we do. So what that means there is a solvent company is one that can basically pay their bills as they come due. And businesses close down for a lot of different reasons. It might not be because they're actually in financial difficulty. It might just be that either they're retiring or whatever, or maybe in the COVID crisis that they just don't see that they can trade through it, and so they would rather close a business before they end up becoming an insolvent business. So I guess my only sort of thought on that today is that, like most things, there's a lot of fish hooks and there's a lot of things to think about. So, you know, a lot of people sort of think, oh, it's really easy to close a company, just don't file your annual return and the company will go away. And, you know, I remember being taught this sort of analogy of, well, how deep do you want to bury your slightly dodgy uncle? Do you want them just below the surface, fairly deep, or do you want them absolutely 6 feet under? And so, you know, what we help with clients is actually establishing, you know, what sort of process works best for them. Have they been trading for a period of time, or was it just a business that was sort of set up and never really got up and running? So I'm not going to go into too much of the detail, apart from to, I suppose, just say that if you are thinking about closing your company, there is quite a bit to think about, and there is actually a real process that you need to follow through. So what we do is a lot of these short form removals, and it's a case of you do need to get IRD approval. So that means you need to have filed your tax returns with the IRD and have your taxes up to date. You do need to actually do the proper resolutions and everything to start that process. And there's just a few things to think about. There could be dividends on winding up and that sort of stuff. So not going to go into all this accounting jargon that would probably put a lot of people off, but just really please, if you are thinking about closing your company down, make sure you do talk to your sort of business advisors there. So that's probably a bit from me, Brad.
Awesome, thanks, Jo. And look, sounds like there's some, you know, really good stuff in that small business cash flow scheme that you were talking about. I saw that with interest earlier this week, and yeah, it'd be interesting, obviously, to get some further detail around that. But you know, that might be a viable option for some businesses. Obviously, repaying in a year's time could be difficult, but having that extra time, that might be a good avenue for some businesses to look at. Just picking up on what you're saying about the planning is something I'm going to be talking about in my piece on the employment law stuff and the importance of planning. So that might be a bit of a theme today moving forward into the future. So thanks, Jo. That's great. Rightio, Charles, I'll hand over to you. Thank you.
I'll just unmute myself so that you can all hear me. So I was going to talk a wee bit about trusts today. Trusts, or the New Zealand Family Trust, is one important way in which people will protect assets. And, you know, briefly, the main benefit of a trust is that if you put personal assets into it, you're ring fencing those assets. You're protecting them from creditors by moving the assets from your own ownership to the ownership of the trust. So if you're in business, you quite likely have a limited liability company. But with that, unfortunately, the director is likely to have to give their personal guarantees for a number of different things. It might be for the supplier product, or it might be for a personal guarantee under a lease, or certainly for the bank is likely to require a personal guarantee. So while these can't all necessarily be avoided or be, you know, find a way around those, if you put assets into a trust, certainly in some circumstances, it can be highly beneficial. You can't, however, just throw everything in a trust and expect that that means that your creditors can't get it if your business falls into, you know, runs into trouble. There are clawback periods under the Insolvency Act. So 2 years, 2 years for any gift to a trust, and a further the time period 3 to 5 years if, when you made the gift, you were in fact insolvent, you were unable to pay your debts at the time you made the gift. So the two keys are 2 years and 5 years before those assets are really safe in the trust. People also have trusts in order to try to avoid relationship property claims. I haven't got the time today to go into the sort of details about whether or not that's going to be successful, the circumstances that, you know, it might be successful, or the ways in which trusts can be busted by relationship property claims. But certainly in some circumstances, trusts can be useful in that area as well. we're facing very uncertain times at the moment. I know, a lot of people will be very nervous about what the future holds. So it might be a good time to consider whether a trust is for you, although it won't be an instant fix by any means. But others of you may already have trusts, and I would suggest that now is a good time to consider reviewing your trust. We've heard some horror stories over the years in relation to trusts. People perhaps think that they put a particular asset into a trust. Perhaps they thought they put their family home into a trust. They remember talking to their lawyer about it. It was some years ago, and then they find that in fact they didn't put the house in the trust at all, actually, and that obviously means it's not protected. Another example is you lend the money to the trust so the trust can buy the house. The trust then owes you a whole lot of money, and you forget to gift that money back to the trust. So that is actually an asset that you hold. The debt that the trust owes you as an asset, and as such, it's vulnerable to creditors or other potential claims. So it's a good time to have a look at trusts, have a think about whether you've got one and whether it's fit for purpose. We have the new Trusts Act, which is coming into force in 30th of January 2021. It was passed in last year, 2019, so we've got quite a lead in order to have a look at the trusts that are already established and see whether or not they're still fit for purpose, whether they come up to scratch, and what, if anything, may need to be changed about them in preparation for the Trusts Act to come into force. Briefly, the Trusts Act clarifies certain duties that trustees cannot avoid, and it introduces a new liability of gross negligence. Regardless of whether or not your trust deed indemnifies you, if you're found to have been grossly negligent in the management of those assets, you will be held personally liable. And it also makes it easier for beneficiaries to hold trustees to account. And importantly, and possibly one of the most controversial aspects of the Act is that it requires you to provide information to beneficiaries, and I can talk a little bit more about that later if I've got time. In terms of the mandatory duties that the Trust Act will bring into force, one of those is, and I'm not going to go through all of them, I don't want to list, there are about 10 of them, I think. But one of them is that you must know the terms of the trust, and you must act in accordance with the terms of the trust. You must act honestly and for the benefit of the beneficiaries. So those are some of the key duties that they already exist. I mean, the reality is that a lot of the Trust Act is actually codifying, what we call codifying, what is already in the common law, it's already in trust law. But by doing that, it's clarifying it, and it's ramming it home, really, that these are your duties as trustees. So if you are trustees, I would encourage you to think about reviewing your trust, and that can be by using a lawyer, or in the first instance, it's about you having a look at the trust and that you're responsible for. If you're going to review that, so it's a question of where do I start? How do I, what do I do? And the first thing really is to identify all the relevant trust documents. If you haven't got them all together, gather them all together and have a look at them, have a read of them. You're required to know the terms of your trust, so you've got to have a look at the trust deed. And that means you really need to read that trust deed. It's quite common in New Zealand family trusts to have, your mum and dad trust. You'll have mum and dad will be the trustees, but they've also roped in a mate to be a trustee as well. These obligations apply to all the trustees. So the independent trustee who gets no benefit from the trust, they're not going to get a chunk of the assets at any time, but they're still obliged to know what the terms of the trust are and to act in accordance with the Act. So I would have a look at things, the sort of things that you want to look out for is, what does the trust deed say about the number of trustees? do the decisions have to be unanimous, or can they be made by majority only? Who are the beneficiaries? Are the classes of beneficiaries quite narrow, or are they quite wide? You know, is it just, you know, mum and dad, their children and grandchildren, or does it, you know, some trusts will include your children's husbands and wives and their ex-husbands and ex-wives, you know, other, you know, all sorts of, you know, other family members, you know, perhaps, you know, cousins and people like that. It was quite common to have large classes of beneficiaries or wide classes of beneficiaries some years ago, but it's more common now to have much more narrow classes of beneficiaries. And with the Trust Act coming into force and the requirement to provide information to those beneficiaries, it's actually quite good. You need to know who those beneficiaries are that you're going to have to provide information to. And you might want to consider whether, in fact, that trust vehicle is the ideal vehicle for you, particularly if, you know, your daughter's ex-husband and you don't get on very well. But he's a beneficiary of your trust. So, you know, just to bear that in mind. As you go through this trust deed, have a look, keep a lookout for any drafting mistakes that might have been made. We obviously at Godfreys, we haven't made any of those, and we sincerely hope that you wouldn't find any. But occasionally you do come across things. A couple of things that I came across recently, or heard about recently, was the word unanimous being written as anemones. So you know, the trustees had to make anemones decisions, you know. And another one, there was a reference to the appointor, and an appointor is a position that you can hold in a trust, but this particular trust didn't have an appointor. The term wasn't defined, and it was almost certainly because there had been a bit of a mix-up with the underlying documentation or precedent that the lawyers had used. A large national law firm, I should say, not Godfreys. And consider the language of the trust as well. If you don't understand the trust deed you're reading, then how are you going to keep within its terms? How are you going to do what it says you're supposed to do? And you might want, in that situation, you might want to consider resettling the trust. Some of the trusts around are, particularly the older trusts, the language is incredibly archaic. It is impenetrable. So you might need some help with that. And you might want to think about resettling it. Most importantly, make sure you know what the property is in the trust. What's the nature of the property? This is all the trustees need to know this. You know, what are the bank accounts? What's real estate? Are there any shares, etc.? And are the trustees recorded as the legal owners of that property? You know, are all the trustees on the title? Are all the trustees on the bank account? How are, you know, what are your financials like? And I'm sure anybody who's a client of PKF Fox will have excellent financials. But if you, it's important that you keep proper financial records, particularly obviously if it's a trading trust and there's any any income is being earned. Have a look at the documentation to see if you can work out what the purpose of the trust is. The letter of the wishes that was done by the settlers. This might be yourselves, so you know it's quite obvious. You know, I set it up to protect my assets and to look after my kids. That's not a problem. If you've made distributions from the trust, how were these made? Were these properly recorded? Do you keep minutes, resolutions? Are resolutions made and these are recorded and these are signed? All of this stuff should be together. You should keep it together either electronically or in a you know, a big folder, and all the trustees should have access to that information. Do you have regular meetings? Really important. You know, even if it's just a mum and dad trusting you through the family home into it, you know, a decade ago. Have you had a meeting about it ever since? You know, have the trustees satisfied themselves that their property is properly insured, and that it's being maintained? You know, that can be quite a short meeting over a beer. It doesn't have to be something too formal, but keep minutes and you know, keep those minutes. are all the trustees fully involved in the affairs of the trust? If you've got a silent trustee and you're that silent trustee, you might think it's time now to look at resigning from the trust if you're not going to be fully involved. It might be better if if there is a professional trustee appointed rather than a family member, but that will depend on the circumstances as to whether that's right or not. So those are some of the things you'd be wanting to look for if you're reviewing your trust, and certainly some of the things that I would look for if I was reviewing a trust. We obviously can do that work for you and provide advice to you of where things are at, but that shouldn't be instead of you familiarising yourself with the terms of the trust. You do need to know that. A little bit more about how am I doing for time? I've probably had my 10 minutes, haven't I? Yeah,
I think if you just move to wrap it up another minute or so, Charles. Yeah, cheers.
I don't want. Yeah, I won't go on and on. I could say more about about the information that will be required under the new Act, but we can leave that to another day. And I'll say back to you, Brad.
Awesome, thank you, Charles. There was really some really good stuff in there, and the thing that really echoes for me, and look, sadly I've seen it many times over the years, is the point you raised earlier in your presentation about clients thinking they had a certain asset in the trust. I mean, I know it sounds quite incredible. How could people not know what's in their trust, or what's there, or what isn't there, and how can they be confused about that? But sadly, I've seen that over many years because there are steps involved to put assets into trust. There's documentation required, and there are a number of different things that need to be attended to actually get the property in there. It's not just saying, oh, well, my house is in the trust. There's a whole train of paperwork that needs to be attended to actually make that transfer happen, much in the same way as you'd buy a house personally, maybe streamlined in some respects, but it's all got to be done. And if it's not done, but you think it's been done, then you could be in for a real rude awakening and shock. And certainly I've seen it many times because people, have the conversation with their lawyer or advisor and so on. I want to put that into the trust. And generally, what ends up happening is a lot of people put the family home in, but forget other stuff that might be equally important or valuable. And we end up chasing clients about that. And often what happens is sort of that conversation goes cold. There's only so many times we can be the squeaky wheel, and then a lot of people seem to form a view in their mind, a misplaced view, sadly, many times that they'll put something in the trust, in fact they haven't. So I encourage you to go back, look at the source documentation that Charles was talking about, gather it all together, see what you've got, and if you spot any gaps, or there's something that doesn't look right and you feel there's something missing that you believe should be there, then by all means get in contact with us, the usual advisor, to discuss that and see what the situation is. Don't delay and become familiar with the terms of your trust deed. It's going to become absolutely mandatory, and we're here to give help if you need some help deciphering the impenetrable language. Rightio, so I'm going to shut up now, and I'm going to pass over to you, James. I understand you got some pretty interesting information for everyone today. Thank you.
Hello, everybody. So we've all been listening to the daily briefings and reading the news in the media about some of these relief measures coming in the Companies Act for companies that might otherwise be trading insolvently, who are worried about whether or not they should continue. And last week I spoke about some of the composition arrangements under the Companies Act as an alternative to liquidation. So I decided to have a bit of a look at the bill. The bill was just given a first reading on a day or so ago, and it's now at select committee stage. So my comments today are going to be about this moving document. It's a work in progress. It may in fact change before it becomes legislation. But something that has occurred to me as I've read through it today is how complex these Companies Act amendments often are, especially with regard to dates and terminology, and the more you peel through it, the more you think, wow, it's not easy, it is complex, everybody's going to need legal help with that. So don't be afraid to come and ask us questions, because that's what we do. So one of the very interesting things I've noticed, and this actually applies not only to the Companies Act but also to the Insolvency Act, interestingly, is Parliament seemed to have snuck in without mention, at least not any mention that I've heard, this new sections dealing with the meaning of a related party. So when there's a liquidation of a company or somebody ends up in bankruptcy situation, it's possible to go back and unwind transactions which are called voidable transactions. One thing that has been snuck in here is this idea of related parties, and what it's basically doing is empowering a liquidator or an assignee and a personal insolvency to go back and undo any transactions which are happening with a related party. And it goes on here to define related parties as a grandparent, a parent, a child, a grandchild, a brother, a sister, a nephew, a niece, an uncle, an aunt, a first cousin. And then it says whether or not by step relationship. So there's a very new broad category of related parties. Clearly Parliament are worried that people are going to start selling off all of their plant and equipment cheap to their first cousin from a step relationship. So be wary of that, and that's just by way of humour that I've mentioned that. Moving on to some of the COVID-19 response further management measures bill. A lot of the changes in that bill really are targeted at large organisations. When you hear about the reference to changing of statutory timeframes, what they're talking about are large corporations having to have meetings, voting methods. A lot of this won't apply to small or even medium businesses. So what's relevant here are the changes to the Companies Act. There's a safe harbour provision which is going to operate, at least for the moment, it's proposed to operate until 31 March 2022. So that's quite a long time. The other thing that is being talked about is the business debt hibernation scheme. And this is very similar to the proposals I was talking about last week. The only difference is that you can submit this notice of entering this business hibernation process. You can make that decision unilaterally, and you submit the notice to the registrar of companies, and then you're automatically in that space. You're automatically in that hibernation, which gives you an automatic 1 month protection. So that means that nobody can continue proceedings, nobody can further a Section 289 statutory demand, nobody can repossess, take back leased equipment. Basically, it's a total freeze for a month to allow you to put together a proposal of how you're going to deal with your bills that you can't pay at the moment. What then happens is you have a voting process by those creditors, whether they agree with your proposals or not. Where that's different to the compositions I was talking about last week is that all that's required here is a majority in number and a majority in value, no supermajority. So basically, as long as half of the creditors that represent half of the value of the money owed agree, well then you'll have a binding proposal. Interestingly though, last week the proposals I was talking about have the power to reduce amounts that will be paid to creditors, or to even cancel debt in entirety. So where you often hear people talk about settling on 10 cents on the dollar or 20 cents on the dollar, those options are not available in this hibernation scheme. What you can do is you can defer the payment, you can postpone payment, but you cannot actually reduce the amount that's owed to your creditors. You must pay all of it. So there's a big difference there, and that's something, if you're considering one of these options, that's something to be really aware of. Another point I want to make is these safe harbour protections for directors, where you're making decisions that might otherwise be called into question in relation to perhaps reckless trading or taking on obligations that the company shouldn't be taking on, you still have an obligation to act in good faith. You can't you can't be reckless because you have some protection against recklessness. You still have to follow all the normal sorts of considerations, and what you're doing is you're making those considerations with a view to, even though we can't pay now, will we be okay in 6 months' time? So you're sort of viewing and making these decisions with a lens 6 months into the future, which won't be a perfect lens, but you need to make your best endeavours and try not to be careless. The last thing I want to say is that one of the complex issues I found today when I was reading this is the matter of dates. So to be able to use these schemes I've just been talking about, the safe harbour and the business debt hibernation, your company needed to be solvent as at the 31st of December 2019, which is something you'll need some accounting opinion about. If you incorporated your company earlier this year, then you're automatically allowed to use these provisions if you incorporated between 1st of January and 25th of March. But what is very critical is that if you incorporated after 25th of March, so that's basically in the last month or so while we've been in lockdown, you don't have any access to these provisions. That is something very important to understand. Then the other thing I want to talk about is that if in the future you want to rely on these protections of safe harbour for the decisions you've made, if they haven't worked out, then the burden is on you to demonstrate that you did make the relevant considerations about how you viewed the business would be in 6 months. So in any decision making that you might be doing in the position of director, you need to keep some records. You need to keep some notes and some minutes about your considerations when making those decisions, because you may need to call upon those. So make sure you have a structure with whatever you're doing. Don't just wing it. And on that note, I'll hand back to you, Brad.
Thank you, James. Look, there's some really interesting stuff in there, and that related parties definition is pretty interesting, and obviously the humour you outlined might be the hypothetical fear of Parliament that there might be some business owners that are going to get cute and try and offload assets to family members, but that's a very broad net and all-encompassing almost. So interesting, and obviously some other interesting propositions in there as well, which will be of interest to business owners, especially those with companies. And we're going to talk a little bit further next week about some of these issues. So tune in for that if you'd like to hear more about this topic. Rightio, so thank you, James, and I'm just going to talk a little bit today, some musings on in the sphere of employment law. So to my thinking, there hasn't been any major news from the government in the last week or so on the employment front. As we've said many times throughout these webinars, employment law in New Zealand has not changed. It has not been suspended. It still applies. So the usual obligations that employers owe employees and the obligations that employees owe employers still apply. So there has, however, been some talk and speculation that the wage subsidy scheme might be extended beyond 12 weeks, the initial 12-week period the government put forth, especially for some industries that have been really hard hit, such as hospitality and tourism. I wonder if that will materialise, especially given that we're going to get an announcement this coming Monday on when level 2 will come in, and whether you know, for example, the likes of the tourism sector will be able to get back and running for domestic tourism, which it seems like they will be able to. So no firm news there as to whether that wage subsidy may be extended. If it were to be extended, I would be picking that it would be targeted and very limited to certain industries and sectors that have really been hardly hit. It's not that all of us had a hit, but some have been hit more so than others. Interesting to me is one commentator made the observation that after the 12-week subsidy period comes to an end, most businesses should be back on their feet. So that's a pretty bold comment, because I think some will still be struggling. Went on to say that if they're not back on their feet at the end of that 12 weeks, then those businesses are simply masking unemployment, which means that those businesses potentially are unsustainable and there are some bigger decisions that need to be made, such as closing down the operation possibly. So that's obviously something to bear in mind. And we've had another businessman, New Zealand businessman and entrepreneur, a guy by the name of Josh Comrie, come out this week and with some comment from his perspective, because he recently completed a survey of 262 New Zealand businesses that represented $1 billion worth of revenue, so not insignificant. Close to 100 of those 262 businesses, so almost 40%, said they expect to cut almost half of their workforce due to COVID-19, with an average cut of around 5 staff members per business. So I didn't see any detail there on the various numbers of employees that those various businesses, the 262 businesses had on board. And I imagine they're right from small operators to bigger operators. But that's pretty astounding, and I realise it's only a snapshot survey, but half of those businesses said they expect to cut almost half of their workforce, around 5 members per business. So that's a pretty sobering statistic if that holds true. Because if we see anything like these sorts of numbers play out across New Zealand's business landscape, then there could be hundreds of thousands of new beneficiaries. And it's hard to see how our economy could support that, let alone the devastating impact this would have on those made redundant and the businesses that used to employ them. So pretty scary stuff, and I don't want to be a doom and gloom merchant, and I know that sometimes lawyers are painted in that way because we're trained to see the worst case scenario and to the hell on the hand basket situation. But it's good to try and be objective about these things and to look at a scope of different possibilities, and clearly that's one possibility. And boiling that down to what I want to talk to today is picking up on a theme I talked about when I was last on this live stream webinar series on the 23rd of April, when I talked about what redundancy is, restructuring and redundancy, and some considerations that relate to those concepts and the sorts of steps that an employer might need to look at taking if that's something that's in the frame of reference for you and your business at the moment. So today I want, in the limited time available, to talk about the importance of being prepared before launching into any restructure or redundancy process with your staff. And just as Jo touched upon in her presentation, it's that importance of preparedness and the steps that need to be gone through. And we all know the saying that failing to prepare is preparing to fail, and this maxim is especially true in this area of employment law. Many of you will be aware that claims of unjustified dismissal are common and very costly to defend. And when I talk about costly, getting it wrong can be in the tens of thousands of dollars and north of $20,000 or $30,000, which is a huge amount of money for any business if you get this wrong. And this becomes even more important in this area because process is all important if you're looking at restructuring your business and therefore need to make some changes with your employees. And often those processes sadly are deficient. In my experience across 20 years of acting for both employers and employees, don't hate me because I do both sides of the fence, but it gives me a good cross section, and I know what both sides of the fence look like. So, the numbers of unjustified dismissal claims for a poorly handled redundancy process would be on par, in my experience, with those claims where an employee is dismissed for misconduct or serious misconduct. So what I'm saying by that is that claims in this area by disgruntled employees are extremely high and happen all the time. So that means you really need to approach this carefully if this is something you're looking at or considering moving forward for your business. Because typically an employment lawyer like me and James and also Andy Ogilvie, our firm, will scrutinise not only the process but also the business case of the employer. I could talk a lot. I am going to talk a little about the business case today. I'm not going to get bogged down in the legal semantics of how far a court can go to talk through a business owner's decision to make or undertake, I should say, restructuring, therefore make certain positions redundant. because that's a whole webinar in and of itself, and will probably send most of you to sleep. But I want to talk a little about the business case today, and that's often cited by employment lawyers as the substantive justification for making an employee's position redundant. So it's really important at this point to be clear that redundancy means that a position filled by an employee is surplus to an employer's requirements. So it's that position is surplus. And that's either due to some reorganisation of the business structure because of changed business performance, changed business landscape, such as what we find with the COVID-19 landscape, due to new or reduced needs for the business or the service or product. And in some cases, and this is quite common with small businesses, a business owner will propose to take over the functions of a particular role or particular roles. So, there'll be a lot of small business owners out there at the moment thinking, well, gee, I could assume possibly the role of one or more staff members, and I could just pick all that up because previously I was only working in the business part-time, but I can do all those things, therefore I don't need those roles. So if a position is surplus, then it often follows that an employee will be made redundant unless they agree to some type of reduced role, whether that be part-time or a contract type basis arrangement, or it's a bigger business and there's ability for that business to redeploy that employee into another area of the business operation. But for many SMEs, that's often not a real possibility. So if a position is surplus and you need to consider restructuring your business to survive through the coming months, then you need to get really, really clear on what any revised structure for your business might look like heading into the future. You also need to have a really solid business rationale for why these changes are needed. It's not just good enough at a one to say, oh, well, I think business is going to be really bad, therefore I need to shed half my staff. That's not going to cut it. So you're going to need to undertake a detailed analysis of your business position. And what I mean by that is your business's financial health and the forecast in terms of your cash flows and profit and loss, moving into the future. And that's obviously where you need to take accountancy advice. So expert guidance here is critical. And often, we were talking about this before we went live today, Joe and I, how great it is for accountants and lawyers to be on the same webinar, because accountants and lawyers often talk in the background about how great it would be if we could be on board with clients from the get-go and talking about their major reorganisation or structuring plans, because we can all get on the same page from the get-go and really add value at that piece of the game. And it's really critical that all of us are across that at the same time, because we bring different strengths and views to these sorts of processes and how they can be handled. So there is real value in getting your team players on board rather than just going it on your own, because the likes of Jo and her team members can help you prepare and interpret your data, which then will help you to fairly and sensibly reach some decisions about what steps need to be taken and how you might look to take those. So once you've got your data together, what do you do? Well, sadly, this is the point that I often see many employers making huge mistakes, because what they often do at this point, once they've got the business case together, is they jump in knees deep and they start firing out communications to staff about redundancies, and that these will be made, and very little, if any, detail around what the process may be. So this is real danger stuff, because if your first communication to your staff is that redundancies will be made, I would argue it's fatally predeterminant of the eventual outcome, and because many employers simply must, under New Zealand employment law, go through a very considered and detailed process, and this must be action before you can make anyone redundant or start throwing around comments that people will be made redundant. So there is, luckily, an easy way to avoid that fatal mistake, because you need to, and it's an easy one to avoid. But what I want to make clear is there are a lot of pitfalls to fall into here. I don't have the time to go through all of them today. But one of the critical things you need to do if you're going to look to go down this line after you've taken specialist accounting and legal advice is you've got to check your employees' employment agreements to see what they say about redundancy. And this is a huge pitfall employers fall into. They charge off in this process and they just totally ignore the fact that buried in the employee's employment agreement is a very carefully spelled out and mandated process that an employer must follow when looking to make an employee redundant. That's not to say all agreements contain these sorts of stipulations or processes, because many don't, they're silent. And what that means, if they're silent, is you can look to design your own restructure and redundancy process, but that process must take into consideration and actually impart the obligations of good faith. So you've got to design a process that's going to meet the various tests there are at law and under legislation in New Zealand. So if you ignore to fail or follow a process to the letter once you've discovered what it is in the agreement, if it's spelled out or you've designed your own one and then you put that out to the team, if you fail to follow that, then any redundancy action you take may be held to be unjustified if that's challenged due to either a breach of contractual terms or for breaching your own process you designed. And as I said earlier, that could expose you and your business to tens of thousands of dollars in compensatory claims. And in some circumstances, and it's now the primary, back being the primary remedy under the Employment Relations Act, employees can apply to the Employment Relations Authority for reinstatement into their roles for unjustified dismissals. So that's probably a reality that no one wants to face. So obviously it behooves you to just take extreme care. So responsible business owners will do their due diligence before contemplating these sorts of steps. And sadly, it may be due to the effects of COVID-19 that redundancy is unavoidable for some businesses. So the key is to get prepared early rather than leave it to the last moment when things become rushed and important safeguards are missed or simply dispensed with, and that's danger territory. So look, I've gone slightly over time, so sorry team for that, but hopefully some important stuff in there, and if you need further advice around these sorts of decisions, then feel free to get in contact with the team, and I'll put the details up at the end of the webinar. Rightio, so that's enough from me. I'm going to move now to the question and answer part of today's live stream webinar. So if you've got a burning question that you'd like to ask the team, then feel free to hit the Q&A function on Zoom and push that through to us, and we'll do our best to answer that query. So I've had some that have come in before, but I see I've got a live one sitting here, so I'll just bring that up. Okay, so I think this might be a question for you and I, James. So this question is, I have a question about the wage subsidy scheme. We are builders and can work at level 3. However, currently our work is patchy due to projects being moved back or scaled down. How do I use the wage subsidy when we have work for part of a week? Do I pay our employees 100% of their normal wages and use the subsidy to support our business cash flow and income? Do I need to consider paying any of the subsidy back because we can charge out some work within the 12-week period of the subsidy? So I might just repeat that. So there are a few different questions there. The first one is, how do I use the wage subsidy when we have work for part of a week? And do I pay employees 100% of the normal wages and use the subsidy to support our business cash flow and income? I guess I'll just chip in there quickly and say, well, you cannot use the subsidy to support business cash flow and income. And James, I might throw it over to you in terms of how they might handle that scenario otherwise.
Thanks, Brad. Yes, for the person who asked the question, I think maybe you're overcomplicating issues for yourself. Basically, you have to pay your employees in accordance with your employment agreement. Just forget the subsidy for a moment. If they're on a salary, you pay them their salary. If they're on hourly wages, you pay them for the hours that they work. and you may have renegotiated that during this time of lockdown, but you must make those payments. Now, the wage subsidy is given to the employer to help them meet those wage costs. So it's to help you pay those wages. That doesn't mean that you have to pay the wages plus the subsidy. It doesn't mean that the subsidy gets treated any differently to those wages. It's to help you pay those wages. There are a few conditions about having to pass on all of the subsidy where the wages would have been less for people that applied later, but we won't get into those details. Basically, pay your guys for the work they're doing and use the subsidy to do that. That's it. And remember, as Brad said, do not be using it to pay rent or other incidents of your business.
Great, thank you, James. That hopefully that answers that attendee's question. Rightio. So keep those questions coming if there's a burning question you'd like us to answer today. So as I said, we've had some come in before today's webinar. So this might be one for you, Joe. This person has asked, with me working from home so much over the last 5 weeks, is it possible to claim more of this expense against my income?
So is the person working from home an employee? Or...
Yeah, look, it's not specified, but look, I'm taking from the way the question's been phrased that I would take it that the person is an employee.
That they are an employee?
Yes.
Yeah, so I mean the rules, if you're on salary and wages, there's very, very, very little that you can claim as cost to offset your salary and wages, basically nothing in New Zealand. But to sort of answer the question properly, if you are a business owner and you're working from home, then obviously you have your home office claim, and so it's really business as normal as far as your home office claim, except you might have slightly higher expenses such as power and you know and whatnot, and there might be sort of a small portion of other costs you can claim. But if you're talking about an employee at home, then it's not really anything that you can claim there.
Great, thank you, Joe. Okay, so rightio. So this, I'll throw this one out to the panel. If the banks are doing new loans of up to 100,000 on interest-free terms, is it worth getting one to repay other company debt, which is incurring interest, and hope for the best in 12 months' time when the loan has to be repaid? Or are these loans just for new ventures? That might be talking about that small business cash flow scheme that you touched on earlier, Joe. So this person's one. Yeah,
I'm
what do you
wondering
think?
about that. Yeah, because I mean the loan's not from the bank in that instance, the loan's from the government, and the loan needs to be used to basically meet your sort of your cash flow needs. So it's your sort of ongoing operating costs. I'd be pretty sure you wouldn't be using it to refinance loans. It needs to actually be for you know day-to-day expenses effectively.
Right. Okay. Makes sense. Rightio. Next one, we've got a bit of a lease question here. This person's lease, rent payment is due again next week. They have a small bar where their patrons normally stand, and although it looks like they'll be able to open next week, it's hard to see how it'll work if people have to be seated and only have one server. I'll probably open because I need some income, but how do I stand with my landlord? He was really good about last month's rent. We did the 50-50 thing, which many others did. But what can or should I try for this time in my circumstance? Any thoughts there, team?
My thoughts are that I see on the Parliament website there's another bill coming with some amendments to the Property Law Act, which might provide the long-awaited framework for negotiating between landlords and tenants, but as yet that's not there. So talk to your landlord. It's better for them to have a tenant that can pay the normal rent in the future than to have no tenant, and likewise it's better for you to stay there than to have to set up elsewhere unless your business is irrecoverable. So yeah, get talking, and hopefully that framework will be out this time next week, and we might reference to it if it has come out.
Right, thanks, James. Righty, it looks like we've got one more here before we do our wrap up, unless any further questions come through. If my business has to close and all the wage subsidy money has gone, will the government come chasing it? If they do, are they a preferred creditor? So I guess that's a pretty hard one to answer because there's not a lot of background to that. But I guess the question is if a business has to close, will the government look for a payment of wage subsidy money? What's your understanding around that?
I'll have a crack at this one as well. That's a very interesting question because normally with regard to tax debt, the Inland Revenue take a role as a preferential creditor in respect of some like PAYE tax, etc. And so do employees in relation to certain amounts of holiday pay or current wages. So that's a very interesting question that I don't have an answer for it, I'm afraid. I would imagine my instinct to this is that the government would simply be an unsecured creditor in the pool because I've seen nothing that specifically gives them a priority over other creditors.
Thanks, James. Okay, right. So look, doesn't look like we've got any other questions that have come through the live Q&A. And I've just realised that in my excitement and haste to get into today's webinar, I skipped the all-important and fun legal disclaimer at the start. So it's better late than never. So look, no doubt, and thank you for joining us today. And you're aware that we're providing this as a free information service and an effort to help business owners at this time. So this webinar and the comments given in it today is not intended to replace detailed accounts legal advice, and you shouldn't rely on today's information or the answers given to support a particular accounting or legal position that you may wish to adopt, because every situation is dependent on its own facts and we don't know all of your individual situations. So any statements or answers we've given today are intended as guidance to assist you, hopefully, with your general understanding of the landscape as we understand it here and now today. So that's the disclaimer. So I managed to get it in, saved by the bell at the end. And look, I'd like to thank you all once again for joining us today and for taking the time out of your schedules, because no doubt a lot of you will now be quite busy at level 3 and preparing for level 2. So thank you once again for joining today's panelists and this live stream webinar. I hope that you found some value from this presentation. And if you'd like to get in contact for a chat today with any of the panelists, then at the end of the webinar shortly, I'm going to put up some contact details. So stay online so you can catch that detail. And once again, if you have any requests for particular topics that are of interest to you, then please feel free to send me an email with your suggestions or requests. And as I signalled earlier in today's webinar, we are going to be running another webinar same time next week. And it's going to have we're going to have a liquidator on board to join us. So really looking forward to that and getting some expert comment and insight from that party. And we're going to be looking a little bit more in detail and some more focus around those sorts of things. So I'm just right that I thought there might have been a question, but there was some thank yous coming in. So thank you very much. We do appreciate your feedback. It's good to know that you're getting some value out of this. So thanks for joining us. And thank you, Joe, once again for joining the panel today. It's great to have you on board and to get your insights and comments. It's been really useful.
Cheers, Brad. Thank you.
Great to welcome you on board today, Charles, as a new face, and some important stuff there. And James, once again, thanks for coming on board with the team and sharing your insights. Appreciate it. So thanks, team. And I'm just going to put up, if I can manage it, the share a screen for our contact details. And take care out there, and I hope you have a great weekend, and we look forward to seeing you again next week. Thank you, everyone.
Can you hear us? So it shows who attended up the side.
Still recording, Charles.
Yeah.
Now,